first witness?
No. PW6.
Maybe counsel, you may need to advise me whether you are conceding to the fact that he was at the scene.
My
Are
Lord,
you conceding to that?
I am not yet conceding.
Okay. PW6 testified that he was breathing heavily.
Yes. And the same PW6 has no expertise to find out whether he had any health challenge. My Lord, further evidence came to court from the accused himself that he was distressed. That he had started living on the street, though adult, but as a street kid. Whereas it came to this court that he had a rental house in Chanda. It calls for investigations, my Lord, that if a person abandons his home and goes to the street, there must be a challenge. My Lord, further evidence came at the time of his arrest. He had painkillers, including diclofenac, and they were exhibited. When we cross-examined one of the witnesses, he said that at the time of arrest, he had those painkillers, and that the previous day was in great pain. The information from the suspect. My Lord, evidence came in court that the accused person entered into various transactions, including a rental agreement, car rental, and he was also driving. My Lord, PW11, at page 31, at page 131, my Lord,
131 of what?
of the proceedings.
PW11 is who?
My Lord, my sister is checking. He stated, a person with a mental challenge can transact, can drive, can even plan how to commit a crime. That is Dr. Norman Emmanuel.
Wamanya.
Okay, my Lord, this is transcribed because the master
Called
has
Wamanya.
much of life. My Lord, did DW2 still confirm he was in Italy?
Did he say a person with a mental illness can do that? Or he said during the time when he's normal, the previous episode?
My Lord, thank you. I pray you're right. During the time when those episodes, he can do business as a normal person.
I've noted that you say that DW2 also confirmed that he was in Tabitha.
Yes, my Lord. My Lord, between 1st January 2026 and 7th April 2026, there is no medical opinion that came to court that this person, medical opinion,
1st January and 7th April,
2026.
the first examination to the other examination on PF24.
Yes. There is no medical expert who came to court that during that period he was normal. My Lord, it's on court record that in February 2026, he applied for citizenship of Uganda. My Lord, during the cross-examination of the doctor from IHK, did PW12, a question was put to him and he answered that it is possible that the Ministry of Internal Affairs might have denied him citizenship because of mental illness. And that his report
Are you able to read that from the report? Just read it out to me. If I recall, I think you put a question to him whether it is not common or whether it is not a possibility that some people are denied citizenship. And for specifically that one, I don't remember it.
My Lord,
help me read the report, please.
My Lord, I pray that you write the record will be before you to scrutinize this.
No, I don't want to write things that didn't happen here because that would be misleading.
Okay, my Lord, let me read my question verbatim.
Okay.
Will I be right according to your experience with the people who are applying for citizenship in Uganda, standing for that report? One of the reasons is that those with mental challenges are not granted citizenship. My Lord, this is the answer. It is possible. It is a possibility, my Lord.
Exactly. That is exactly what happened.
Yes.
Not what you're saying.
My Lord.
Because what you're saying is that he could have been denied citizenship as a result of mental illness. But that's not what he said. You remember? That's not what he said.
My Lord, I pray you write what I've written. What I've read to you.
Okay, I want us to be professional enough so that we bring to the court what transpired in court.
My Lord, if you are to remember, I was not reading on the record. I was quoting for you.
No, but you are quoting for me something that is not accurate. That is my concern.
My Lord, let us continue.
The accurate one is that he said it is possible that somebody could have been denied. Not that this particular person had been denied because of mental illness.
Kindly, my Lord, write what I'm reading.
It is okay.
Much obliged, my Lord. This is what he answered. It is a possibility, my Lord.
Okay. Let's proceed, please.
My Lord, if it is so, the question is, nobody here has knowledge as to whether on the 2nd April 2026 he was normal or not. My Lord, according to the law or authorities, if there is any guesswork and contradiction, those contradictions are resolved in the favor of the accused person.
There is guesswork?
Guesswork or contradiction. Now, my Lord, this court is left to guesswork as to his mental status on the 2nd day.
You picked section 11 and you did not pick section 10 of the Penal Code Act.
My Lord, I read it verbatim.
No, I mean section 10 of the Penal Code Act.
Yes, my Lord, it's what I read.
You read section 11.
I read section 11.
You read section 10. Because section 11 arises out of section 10.
My Lord, you advised we come here for submissions. I did not carry all the laws. It was not adjourned.
It is well. It is okay, Mr. Kumba. Let's proceed.
Yes, my Lord. My Lord, another factor to consider is sickle cell. One of the doctors said is a risk factor. And that such patients, the painkillers alone they go through can lead to mental illness.
As they go through the pain they go through.
They go through as...
And the medication they take.
And the medication they take. My Lord, that is on page 147. And that's the PW12. My Lord, in Uganda, according to section 11, it's established that if a person is incapable of understanding their acts due to the disease of the mind at the time of the offense, cases involve strict psychiatric evaluation, often resulting into special verdicts of not guilty by reason of insanity. My Lord, this was alluded to in Uganda versus Kantinti Joel, criminal section number 87. Criminal section 87 of 2025.
2025? You have a copy?
Yes, my Lord.
You have a copy?
My Lord, I do not have a copy here.
We shall find it.
We shall find it on it. I pray you find it on internet.
Okay, yes.
The court held that the prosecution proved the offense of aggravated defilement. The victim of the offense was 14 years. Sexual act by the accused. The accused was identified at the scene of crime. However, based on psychiatric evidence, the court was satisfied that the accused was mentally ill. And lacked criminal responsibility at the time of the act. Invoking section 49(1) of the TIA, the court entered a special finding of not guilty by reason of insanity. Pursuant to section 49(2), the accused was ordered into a custody as a criminal lunatic at Maction Bay Hospital. Pending direction from the Minister of Justice and Constitutional Affairs. By Honorable Justice, Lady Justice Sarah Langa Siu. your sister. My Lord, at page 11, at PW 11, I mean, not page 11, at page 129, told the court that the symptoms of, I quote, I can't pronounce this word. Yes, my Lord, exactly that word. Comma, delusions, hallucinations, laughing, were one of the indicators of mental illness.
That's what he said. Mr. Kumbu,
At page 129, my Lord.
what did he say?
My Lord, he says, I quote, say, my Lord, symptoms include delusion, hallucination, abnormal posture, incoherent mood, and incoherent affect. Then he defined the meaning of affect.
Okay, it was hallucination, abnormal posturing, then mood what?
Incoherent mood.
Okay.
And he actually quoted again the same page that a person may report that they are hungry, but when they are laughing.
They are angry, not hungry.
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 My Lord, it's age.
I think the person who transcribed and recorded that was not it.
And my Lord, in this court, this particular chosen person has been laughing frequently. My Lord, I invite you to look at PF 24, and I want to read verbatim to this honorable court.
The number? Is it 7? Is it 7?
And I pray you will quote PF 24. We shall be there.
Okay.
It's what I'm reading from.
Okay.
Much obliged. These are his findings. The findings above suggest of a mental condition.
Mr. Kumbuka, please. I thought we agreed, let's be professional now. When you read that PF 24, he made his observations arising from his examination, and then he noted what he told him, and then he's talking about the above findings.
Yes, my Lord, that's why I'm reading his findings. This is not my word.
Not his findings, the findings of that history.
Okay, my Lord, it's all right. You can write like that. But allow me.
Please read.
Allow me read.
Please, go ahead.
The findings of the above are a suggestive of a mental condition with psychotic episodes or psychotic episodes. This is his recommendation. Further, mental assessment is necessary since no medical document were available to me, and he was the only source of information. My Lord, as I started the submission, that prosecution must prove its case beyond reasonable doubt. This being the exhibit of prosecution, and they chose to ignore further inquiries about the same. I pray that this court holds that inquiries were complete as to the mental illness.
Sorry, they chose to do what?
To ignore the recommendation of their own witness. I pray that this was intentional. And that if court holds otherwise, shall occasion gross miscarriage of justice. My Lord, the consequences of failure to rebut mental illness once evidence of unsoundness of mind arises, is detrimental to the prosecution case. No cogent psychiatric evidence was tendered to negate the mental illness of the accused before you throughout the prosecution evidence. Consider to the fact that he was in possession of the information that for 8 to 9 months the accused was in Tanka Hospital receiving treatment.
He's referring to the investigating officer, I think that is Esther Wright, James?
Yes, my lord.
PW15.
At page 223 of the court report. On page 228,
Finish the sentence.
I
You did not finish. You say the fact that he was in possession of information. that for 8 to 9 months the accused was in a Taifa hospital
on mental treatment. Prosecution ignored that. He went ahead to say, at the time of arrest on page 228, the accused had painkillers like a diclofenac. In conclusion, therefore, my Lord, the evidence demonstrates that at the time of commission of offense, Christopher Okello Onyum was suffering from that word I can't pronounce, SHR.
Are you going to diagnose him?
Huh?
Are you going to diagnose the condition?
No, my Lord, I'm pronouncing for it. It's just my final remarks.
No, schizophrenia.
Yes, my
I'm
Lord.
wondering where you're getting that that's what you are suffering from at that time, because it didn't come out in any evidence.
It did, but these are submissions. It's my personal submission.
Where do you find it? Because this is a medical condition, and...
Okay, my Lord, unrevealed by prosecution evidence. Yes.
Okay. You're saying
The
that...
unrevealed medical condition at that time.
So in conclusion, the evidence demonstrates that at the time of the offense, Christopher Okello Onyum, the accused person, was suffering from...
That's sickness.
schizophrenia. But I asked you where you got that from, because I don't have it as my evidence.
My Lord, I got it in KF20 for that word, for my past time.
Okay, let's proceed.
Therefore, I invite this court to come to a conclusion that significantly, Fatore was the one. He was impaired.
I think we have to have a position.
Much of that.
Was he the one and he was impaired, or he was not the one and he was impaired?
My Lord, I'm going to that evidence of participation.
We are concluding. Let's proceed.
I'm concluding on that fact I started with on section 11.
Okay, fine.
Much of like.
We invite this court to come to conclusion that
The fact that he was found with medication at the time of arrest is a sign he had a mental challenge. In case this court finds him guilty, is to find an innocent guilty of an innocent person. To find him guilty is to find
him guilty is
to find an innocent person guilty. This might be erroneous, dangerous to the legal profession, and worry the families in Uganda plus elsewhere that have people with such challenges.
Dangerous to the legal profession and
To the society at large, especially families who have people with mental challenges. My Lord, allow me go to a criminal doctrine of negligence. My Lord, at page 54, nobody was attending to the children out while playing. My Lord, on the record, that on the second day, between 10 to noon, the very cameras that tried to show us that person who visited on first, they were off at the time of this offense was committed. No explanation was given to this court for those reasons.
Actually, the witness says that he established that there was a power shutdown.
My Lord, it should have been the controller of these cameras to come to court to clarify that this person, the witness who testified about that, was not in control of these cameras. That loophole will live to haunt the whole nation. My Lord, it's alleged that it's a security guard and another person that subdued this person and detained him. With all the experiences of the police officers who came here and the land state attorneys who advised, they chose not to bring anybody. The question is, who handed over the alleged person to police? Was he picked on the street? Is he the one? I know that will be answered by this honorable court. My Lord, PW 7 was baptized to be a police witness. Odor, Annette. Her statement was not signed by any police officer. She denied the statement being self-recorded. My Lord, Prosecution tried to give explanation for that. It was overruled. No police officer was brought to this court to verify whether she's a police witness, but probably it was an issue. The court shall leave to guess. There was no police guard or security guard, I mean, my lord. However, my lord, what surprises this court that PW6 said there was. PW7 said there was in her examination in chief. Upon cross-examination, she said there was no, and her statement was tendered in. PW7 is the one who said that she called PW6 to go and attend to the children when they were being attacked. She shouted, in fact, she said she shouted at PW6. PW6 was very silent on that statement. She struggled alone. My lord, with all the negligence, contradictions, and inconsistencies mentioned above, impact the overall credibility of the witnesses and integrity of the evidence. And I invite this honorable court to rule that in the favor of the accused person.
I take it that you are contesting the participation of the accused person?
My lord,
Because I'm failing to get your line of argument, you seem to say the accused person acted out of a mental condition, and now you seem to suggest that actually he's not the one. So you almost leave in court in confusion to know your line of defense and argument.
my lord, I trust your experience that during your remarks you will come up with a very good judgment. Much of that, my lord. My lord, allow me from PW13 go witness by witness. PW13, my lord, AIP, I think, Odong Emmanuel. The camera is the cameraman.
The CCTV analyst.
Yes, my lord. This kind of evidence was very dark as to identify who was in this video. Motorcycle number plate was not seen. The cameras were off on that day. At the circle. Yes. At that particular time, they came on at noon. At noon, 22 hours. Still, the statement of anybody from the manager of this CCTV camera is lacking on record. PW14, Detective Mutaka Jimmy. He told the court that all exhibits were submitted by Inspector Seman, the IO. My Lord Semanda was not brought to court. So who was the IO? These were real exhibits brought to court. Semanda didn't come to court to identify any. So it touches their credibility and integrity to meet the standards of being tendered in court.
I thought we tendered them already.
Much obliged, it is true. But my Lord, this is my submission. My Lord, the same person said that there were no fingerprints lifted. At page 228, he said, I know the consequences of failure to lift the fingerprints, but I didn't do so. This offends the principle of proving a case beyond reasonable doubt. My Lord, PW16, Detective James, PW15. He said he supervised the inquiries. But he was not familiar with the whole police file. My Lord, he quoted to this court that the accused person knew the consequences of his acts, and he told him so. when he was asked whether, as police officer, he knows the consequences or the importance of such a statement, he said yes, that it is very important. When he was asked to point to us in the whole police file where this statement is, he confessed it is not there. My Lord, if at all he knew that this statement is very important and it's the backbone of this case, and all the witnesses plus police experts failed to write it on record, if court holds otherwise, it will lead to gross miscarriage of justice. I invite this court to disregard this statement as being misleading. My Lord, at page 245 of PW16, Mpamizo Agre, plus another officer, my Lord, they confirmed to this court that as in this case was going on by 13th April 2026, inquiries were still going on. My Lord, this kind of evidence touches Article 28(1), the doctrine of fair hearing, and also preparing for defense.
But we never at any one time raised an issue of lack of preparation.
My Lord,
when you raise it now at this time, I find it irregular and almost unprofessional.
my Lord, allow me use Article 28(1), fair hearing, which is a non-derogable right. My Lord, as inquiries continue when court is continuing, it offends that article.
So you did never at any one time raise that when you were proceeding? When they brought that and disclosed it, you never brought it to the attention of the court? So I find it irregular that you're raising it now.
My Lord, let me allow me to give you this explanation. My Lord, it's not the defense to prepare the prosecution. As defense, I can look at evidence and do not cross-examine on it because I know it's irregular. In my submissions, I put it there.
No, you don't do that because it is not right. If you thought the disclosures were given to you and had no adequate time, you should have informed the court and I would have given you that time.
My Lord, I concede that wisdom, but as I was cross-examining, witnesses were conceding to that fact that, and they were reading to this honorable court that I made my report on the 17th day, April 2026.
That That's very true, but at the time they came to testify, the disclosure was made to you, and you never at any one time informed the court that you had limited time to be familiar with the reports, which time I would have given to you. So when you raise it now, I am again saying it is irregular.
My Lord, I pray that you allow me quote this. At submission, any offending of the law can be brought to the attention of court.
But
my Lord, thank you for the overruling me.
And of course, this is of course without any offense. Okay? Yeah, because you see, if that's the reason you are there, if you have any issues with either late disclosure of some of the evidence, you should have brought it to the attention of the court, but you did not.
Much obliged, my Lord. PW 17, my Lord. Assistant Superintendent of Police, Haleriman Barnabas. My Lord, he said that the bodies were tampered with of the late by the time an examination was carried out.
You didn't see
the scene of crime.
Mr. Kumbuga,
Yes, my
this
Lord.
is a DNA analyst.
Yes, my Lord.
He did not see the bodies. He saw samples from the bodies, the swabs from the bodies, but not the bodies themselves.
Much obliged, my Lord. My Lord, let me read to you this verbatim,
Okay.
and then you advise.
Okay.
The suspect's shirt shown that there was only the DNA, yet we were told he was subdued and arrested. By the time, by people, by the people. How come that the DNA was not found on his shirt? That's the question, my Lord, this honorable court should answer.
No, I don't answer questions. I want you to read for me that and which witness said that.
My Lord, it is PW 17. On page 267. My Lord, this is what he said. Let me read it verbatim. And my Lord, I don't intend to put there my opinion.
It is okay. You can read it.
If the specimen is not donated, still I can easily know that the specimen has a mixture. But on analysis, the person with the mixture is not among the people who has been donated. That's the statement. My Lord, I pray that you will find out of the record for your analysis of the evidence.
That's fine.
Much obliged. My Lord, the last PW18, Angulo Kenneth.
Prosecution, is it L, is it R? Angulo.
It is L, my Lord.
L. Double L.
My Lord, he said his investigations depended on court order. I asked him whether in his report there is not so motion. He said no. The affidavit was not deponed. The order lacked a court seal. The signature on the order is the same as the signature on the commissioning officer. So in case
The signature of the
order,
officer
the signature of the on the court order, the alleged court order
of the judicial officer.
of the alleged judicial officer
Okay.
is the same as the signature on the affidavit commissioning. My Lord, I trust the body that recruits the judicial officers in Uganda. I don't think in Uganda there is a judicial office who can come up with an order at the same time with commissions. And if we so, in case this judicial officer is identified, I think should be forwarded to the Judicial Service Commission. But there is no court seal to identify the court that participated in this. Therefore, where did these documents originate from that led to this kind of inquiry? This particular evidence was brought to the attention of court. Prosecution ignored to bring any witness to clarify on this. Therefore, in the absence of the officer from court, I invite this court to hold that this does not amount to a court order. Therefore, whatever is started on falsehood, the end must be false. I pray that while coming up with this judgment, court disregards this evidence. However, I will go ahead and continue analyzing whether it was relevant or not. My Lord, in cross-examination, this particular investigator was asked whether his name is on the record. He said it is not there.
On the report.
On the report. And I believe my Lord is well learned to know the consequences of failure to write your name on a report. Because he is a professional police officer. And he was asked whether his national ID has his name. He alluded, he said it is true, his name is there. so he knows the consequences. My Lord, this person was asked whether the alleged police hotline 112 and 99 were called on, and whether he has any writing or voice email to show that that voice is connected, accused in court. He said he has no writing or voice email. And he alluded the fact that he has left it for court for guesswork. My Lord, on issue of Google search, he alluded the fact that doing a search on Google does not offend any law in Uganda. He was asked whether he knows his investigating colleagues went to find out whether this person, after Googling, went to the particular schools, particular institutions. He said he doesn't know. So this evidence is on court record idle. In case they wanted to rely on it, it offends the principle of proving a case beyond reasonable doubt. Meaning his search on Google never offended any Ugandan. My Lord, the concluding remarks on this kind of poor investigations is stated herein. Poor investigations are not mere administrative errors, but systematic breakdowns that cause profound harm poor investigations and negligent inquiries frequently result in too wrongful detaining innocent individuals. My Lord, allow me rest my submissions here, and I leave it to court to determine as to who participated in this kind of right. I press so.
Thank you very, very much.
Much obliged, my lord.
Prosecution, let's have a health break of 10 minutes. Organize yourselves, we come back here in 10 minutes and I hear from your side.
Hello. Don't go away, we are coming back, just 10 minutes.
Kote umuddemu dakika 10 zokka temugenda.
You have an indication of how much time you check?
My lord, we think 1 hour.
1 hour. Now, 4:35, so we're talking about 5:35 or thereabout.
And Anna is the keeper.
And please at exactly 5:35, you tell your brother to stop. Okello is not here.
Criminal Session Case number 132 of 2026, Uganda versus Christopher Okello Onyom.
My lord, Mr. Okello is
Still
not
waiting
here.
for Mr. Okello.
My lord, for the record, we are as before, except that I think by the time we commenced, Mr. Stanley Okello wasn't put on record. My lord, again, to kind of save on the court's time, we have made a write-up which we passed over to the defense, and we pray to pass a copy to court containing the details of our submissions and the authorities that, some of the authorities that we shall be relying on. So that, my lord, I will then save a lot of time to simply run through some of the general issues.
Thank you so much for that.
Thank you, my lord. Your lordship, the ladies and gentlemen assessor, my lord, you allow us highlight our case in response to the submissions of the defense. They have accused is indicted 4 counts of murder, my lord. The ingredients are 4. The first being that we have a burden to prove that a human being, or human beings in this case, were killed, that the death was caused by an unlawful act, and that the unlawful act was actuated by malice, aforethought, and that it is the accused person who participated in the causing of the said death. My Lord, we have the burden to prove all of those 4 ingredients, and we have highlighted the law, my Lord. What we want to emphasize, that
I want some interpretation. I received a concern that the people here would like to have an interpretation. So she's going to interpret.
my Lord, in that case, it will not be 1 hour. We were proposing, my Lord, like the land registrar did after the defense, that after our submission, then the interpreter can recap the gist of what we are saying. Otherwise, my Lord, the interpretation will take half of the time that we are supposed to be addressing court.
Let me hear from the people themselves. Who is their representative?
ani abakiikirira abantu abatuddeeyo?
Could we interpret at the end of their submission a summary of what they have said?
Yes.
At the end. Okay, thank you.
Kale mwebale nnyo.
Thank you, my Lord. My Lord, we want to emphasize that although we have
Look, Mr. Morgan, you proceed to the hero is going to talk to these people. We interpret after some time. Okay, Mr. Morgan, please proceed.
it's all right, my Lord. My Lord, I was highlighting that although the prosecution has the burden to prove the ingredients of this case beyond reasonable doubt, the principle in Mira versus Minister of Pensions, my Lord, that we quote, is that that burden of beyond reasonable doubt does not really mean proof beyond a shadow of doubt. We address you, my Lord, on the first ingredient, that a human being died. The law is that, my Lord, death can be proved by either production of medical evidence to prove the fact of death, or through evidence of eyewitnesses that witnessed the same. In this case, we produced evidence of PW1, and through him, my Lord, we have exhibits, prosecution exhibit number 1 to 4, proving the fact that the bodies of Eteku, Seryange, Agenoroth, and Odeke were examined, found to have had deep cut injuries to the neck that resulted into their death. My Lord, besides the doctor, we also laid evidence of PW2, 3, 4, and 5, who are the biological parents of the deceased children, that testified to the effect that these infants died and were buried. In addition, my Lord, we laid evidence of PW 6 and 7, the caretakers of the center, both of whom testified to the fact of death of each of the children, the deceased children. And finally, my Lord, we had evidence from the police officers, that is PW 14 and 15, whose testimonies were to the effect that the bodies of the deceased children were collected from the scene and Wenzi Medical Center, respectively, conveyed to Mulago KCC mortuary for post-mortem examination, and thereafter released their respective parents for burial. Now, our submission, my Lord, is that that evidence is sufficient to prove that ingredient. I don't know, my Lord, if this would be an appropriate time for us just to wrap up what that, yeah.
Ti mukuwumba musango oludda lw'omwaba gavumenti avunanibwa okutta emisango gy'okutta ena, ng'era emisango gino kakasibwa. Ekisooka walina okubaawo abantu abattiddwa. Ekyokubiri walina okulaga nti ekyaviirako okufa kyali kikolwa eky'obumenyi bw'amateeka. Ekyokusatu kirina okuba nti ekikolwa ekyo kyali kiteeketeeke. Ekyokuna nti avunaanibwa ddala yeyeetaba mu kuzza ebikolwa bino. Ajulizza omusango ogulaga nti mukubanga nti bateekeddwa okuba nga baleeta obujulizi naye nga obutabaamu kubuusabuusa. Ensonga esooka bagenze ku eno ey'okuba nti waliwo abantu abattibwa era baga baleeta obujulizi. Omujulizi eyasooka era nga muye mwe bayitira ne baleeta ebizibiti ebyalambibwa ekisooka mpaka ku kyokuna, nga bino bikakasibwa nti waliwo emirambo gy'abantu bano Eteku, Seruyange, Egenoroth ne Odeke, era nga gino gyasangibwa nga gisaliddwa ebiwundu mu bulago ekyabaviirako okufa. era bamala ng'oggyeko obujulizi obwo bamala ne baleeta obujulizi abajulizi abalala nga kwe kuli omujulizi owokubiri owokusatu n'owokutaano nga bano be bazadde b'abaana bano abagenzi ng'era nabo baawa obujulizi bwabwe nti abaana bano baafa era ne baziikibwa. Olwo olwabiro bagenda maaso ne leeta abajulizi abalala ow'omukaaga n'ow'omusanvu nga bano be baali balabirira abaana bano kweno senta obw'essomero lino ng'era na bano bakakasa mu bujulizi bwabwe nti abaana bano ddala baafa. Bagenda maaso ne baleeta obujulizi bw'abasirikale abapoliisi nga bano be bajulizi ow'e18 n'ow'e15 era nga bano nabo baawa obujulizi bwabwe ne bategeeza nti baafuna emirambo okuva wano wenyini ku ssomero n'emirambo emirala ne bagijja ku ddwaliro lya Wenzi era ng'emirambo gino baamala gyonna ne bagikuŋŋaanya ne bagitwala ku mokyale e Mulago okukakasa oba okukeberebwa okuzuula ki ekyali kiviiriddeko okufa kw'abaana bano era oluvannyuma lw'okukebera emirambo gino ne giweebwayo ne giziikibwa.
My Lord, as to the second ingredient, that the death was caused by an unlawful act, the law is settled. That any homicide, my Lord, is presumed to be caused unlawfully unless it was accidental or authorized by law. In this case, my Lord, there is nothing that was laid to rebut that legal presumption. Nothing pointed to the homicide in issue being either accidental or justifiable or lawfully caused. Although the defense were not clear in their submissions on this particular ingredient, my Lord, we did not hear any contestation from them to the effect that this death was not caused through an unlawful means. So we submit that that ingredient is also properly established. My Lord, the third ingredient.
Yes, better interpret ingredient than ingredient.
Okay.
Ensonga endala erina okukakasibwa oludda oluwaabi y'ey'okuba nti okufa kwaleetebwa oba kwakolebwa ekikolwa ekitakolebwa mu bumenyi bw'amateeka. Waba gavumenti agamba nti etteeka lyakakasibwa nti buli okufa kuba kumenya mateeka okuggyako nga waliwo ekikakasizza nti tekumenya mateeka. Oludda oluwawaabirwa teruleeseeyo oba terulazeeyo nsonga yonna eraga nti okufa kuno tekwamenya mateeka oba nga kwali kwagwawo mu butanwa oba nga kwaliwo mu mateeka era nga oludda olwabi teruleeseeyo kulaga nti okufa kw'abana abaafa kwali mu mateeka.
My Lord, on the third ingredient, that the death was caused with malice aforethought, my Lord, reference is made to the provision of section 174 of the Penal Code Act, which defines malice aforethought as either an intention to cause death of a person or the knowledge that an act causing death will probably cause the death of some person. Now the question that your Lordship has to answer is whether whoever assaulted the deceased children in the manner described through the evidence of PW 1 and other eyewitnesses intended to cause death or knew that such assault would probably cause death. My Lord, malice aforethought can be inferred because it is a mental element. It can be inferred from the circumstances, and we have provided authorities, my Lord, to highlight some of the circumstances from which court can make an inference. My Lord, these include the type of weapon used. And my Lord, in this case, the weapon is a knife, which is a deadly weapon. The second circumstance, my Lord, is the nature of injuries inflicted and in our case, we have deep cut wounds to the neck. The other consideration is the part of the body affected. We submit, my Lord, that in this case, that part of the body was the neck, which is a vulnerable part of a human being. And the fourth consideration to consider, my Lord, is the conduct of the accused person, either before, during, or even after the attack. My Lord, we have led through the various witnesses incontrovertible evidence speaking to the prior planning of the accused and his meticulous execution of his plan. Part of that evidence, my Lord, is the testimony of PW6, to whom the accused disclosed that he scouted the scene of crime a day before, we also, my Lord, have evidence of PW 8, from whom the accused hired a motor vehicle to ease his scouting movement on the 1st of April this year. We have also highlighted evidence, my Lord, to the effect that in the process of executing the victims, the accused scared off PW6 who was attempting to rescue the children. But my Lord, the same witness also gave evidence to that effect that after killing the children, the accused threw away the knife. An act that we submit was intended at concealing evidence, knowing the fatal consequences. My Lord, the participation of the accused person
ensonga endala yekigendererwa nga kino enennyonnyolwa akawaayiro ak'E174 ak'etteeka ery'ebibonerezo nga wano kino oludda oluwaabi lwaleeta abajulizi okukakasa abaaliwo okulaba ebikolwa bino nga bigenda mu maaso, ng'era kuno kwe kuli mu kunnyonnyola, kuno kwe kuli
akawaayiro akalala ka kigendererwa omuntu ng'akoze omusango bwe guti, balina okulaba nti oba omuntu oyo yali amanyi oba ekigendererwa kye yalina okukola omusango bwe gutyo, n'agamba nti omuntu yenna eyafumita abaana abo mu ngeri gye yabafumitamu yali amanyi, yali alina ekigendererwa. Omujulizi eyasooka n'abalala baaliwo bagamba nti yakigenderera okukola ekyo kye yakola ate ne kiviirako abaana okufa. N'agamba nti ekigendererwa bakirabira ku bintu bingi kubanga kibeera mu mutwe gw'omuntu, ate ebintu ebyo basobola kulaba ku kisi ekyakozesebwa ng'akambe kubanga akabulabe, basobola kulabira ku biwundu oba obuvune obutuusizaako omuntu nga mu musango guno abaana bano babasala mu bulago era balina okulaba ekitundu ki omuntu kyatuusizaako obuvune, era mu musango guno omuntu ono yafumita obulago, ate obulago kitundu kya nkizo nnyo ku mubiri gw'omuntu, era balabira n'engeri omuntu gye yeeyisizaamu mu kukola omusango ogwo ng'amaze okugukola.
My Lord, we submit that with that evidence establishes the ingredient of malice aforethought. The fourth and final ingredient of participation, we read both direct and circumstantial evidence to not just place the accused at the scene of crime, but, my Lord, to prove that he directly participated in causing of the death of the 4 infants. Again, my Lord, we highlight the testimonies of the 2 eyewitnesses, PW 6 and 7, my Lord, we also highlight the fact that the accused was arrested at the scene. My Lord, we also laid evidence of PW 17, whose findings were that the accused's trousers in Prosecution Exhibit 16 bore the blood of one of the victims. In addition, my Lord, on the recovered murder weapon, the knife, evidence found the DNA of the accused on the knife handle, which was Exhibit 4. Among the examined items, to be the user of that knife that killed the infants. My Lord, there was also evidence from the sunglasses of the accused of the DNA of body 39, which belonged to one of the deceased children, Keisha, again Roth. My Lord, on the accused's trousers, it was DNA of body 37 of Ignatius Seriange.
What was on the trousers?
DNA of body 37, which body, my Lord, belonged to Ignatius Seriange. My Lord, that evidence and more that we read on record is sufficient to place the accused at the scene, but also prove his direct participation. we want to add, my Lord, that throughout his defense, the accused never denied causing the death. Of the deceased children. He only claimed that he believed he did not have the intention to cause their death. He claimed that he was distressed between January and March this year, and that his killing of the 4 children on April the 2nd could have had something to do with his alleged distress. My Lord, from the accused's defense, we understand him to be raising a defense of insanity, for which we want to address court.
nti kyokulaga oba omuwaabirwa yeyaza omusango guno oba nedda, baleeta obujulizi obw'enjawulo. Obujulizi buno bumuteeka bumusanga we bakira abaana, ate ne baleeta obujulizi bulaga nti ye yabatta. Baleeta obujulizi bw'abantu era bagamba nti omwami Okello bamukwatira mu kifo abaana abo we bafiira. Baleeta obujulizi bw'omujulizi wa 17 era yajja n'agamba nti empale Okello gye yali ayambadde gye bayitanga ekizibiti ekyo16 yaliko omusaayi gw'omu ku baana baafa, era omwana oyo omulambo baali baguwadde enamba 37 ate nga gwali mulambo gwa Seruyange. Era ne baleeta obujulizi obulala nga bagamba nti akambe akakozesebwa kaliko endagabutonde ya mwami Okello. Nti ekyo kitaga nti mwami Okello yakozesa akamba ako. Obujulizi obulala buva ku galubindi ezaali za mwami Okello, bazikebera ne basanga nga zaliko omusaayi gw'omulambo gwe bali bawadde namba 39 nga gwali gwa Keisha. Nti obujulizi obwo n'obulala bumala okulaga nti omwami Okello yali mu kifo ekyo era yaza omusango guno. Nti yali nga yeewozaako ye teyeegaana musango, wabula kye yeegaana kyokka yali agamba nti ye kino teyakigenderera okuvaako okufa kw'abaana abo. N'agamba nti wakati wa mwezi gwa January ne Maachi omwaka guno yali alina obuzibu, yali mwenyamivu. Nti ate agamba nti kyandibanga kye kyamuviirako okutta abaana abo ng'ennaku z'omwezi 2 ogwokuna omwaka guno. Nti mu difensi ye alabika nga agamba nti yali omutwe gwe tegukola bulungi, era kati omuwabi wa gavumenti kyagenda kwogerako.
My Lord, this defense of insanity seeks to do away with the essential ingredient of malice, aforethought. And when this defense is raised by any accused person, in any criminal trial. My Lord, the starting point is Section 10 of the Penal Code. My Lord, you will allow me to read Section 10 verbatim. It provides that every person is presumed to be of sound mind and to have been of sound mind at any time which comes in question until the contrary is proved. In other words, my Lord, there is a legal presumption that every living being is sane. And whoever wants to dispute that presumption of sanity, my Lord, bears the burden to prove the contrary. And therefore, my Lord, it is not right that the defense faults prosecution for failing to lead what they termed evidence of his sanity. My Lord, that
About evidence of his insanity.
for failing to lead evidence of his insanity, I beg your pardon, my Lord. Evidence of his insanity. My Lord, that burden is not shouldered by the state. Because as far as the law is concerned, every man is the same.
How about women?
That's exactly what Anna is complaining about. So, my Lord, by man, I actually mean both men and women. Every person. Every person. And my Lord, this principle has been exemplified in several authorities. We have quoted one of Nsabimana Richard, my Lord, versus Uganda on page 8, where our Supreme Court held that every person of age of discretion is, unless the contrary is proved, presumed by law to be sane and to be accountable for his or her actions. That the onus is on the defense, and my Lord, we want to highlight that the burden is on the defense to establish such insanity on the balance of probabilities. In our submissions, my Lord, we highlight other authorities that speak to the same principle. Maybe if we want to just summarize.
Ekyokugamba nti oba omutwe gwe gwali kukola bulungi, bwe boogera ku kyokugamba nti omutwe gwe gwali tegukola bulungi, kiba kijjako ekyokugamba nti yali agenderedde kye yakola, nti naye oludda oludda lw'omuwaabirwa bwe bagamba nti omuntu ono omutwe gwe gubadde tegukola bulungi, kooti erina okugenda ku mateeka akawayiro ka 10 mu kitabo ky'ebibonerezo, ate nga kigamba nti buli muntu mu mateeka bamutwala nti ategeera bulungi era omutwe gwe gukola bulungi, okujjako nga baleese obujulizi obulaga nti omutwe gwe tegukola bulungi. Kigambirwa nti buli muntu akola bulungi mu mutwe, nti era bw'ogamba nti toli bulungi olina okuleeta obujulizi kukikakasa. Nti ate abaludda olw'omuwaabirwa si batuufu okugamba nti ab'oludda oluwaabi balemererwa okuleeta obujulizi obulaga nti omwami Okello yali omutwe gwe tegukola bulungi. Nti bw'ogamba nti omuntu omutwe tegukola bulungi, oludda oluwaabi terulina kuleeta obujulizi okulaga nti mu butuufu oyo yali takola bulungi mu mutwe, kubanga kusinziira ku mateeka kigambirwa nti buli muntu abeera bamutwala ng'omuntu ategeera bulungi. Nti ate ensonga eno waliwo emisango emirala kooti ezawaggulu gye zisaze okulaba nga okwa Nsabimana vs Uganda mu musango gwa Supreme Court, era bagamba nti buli muntu alina emyaka etegeera bamutwala nti omutwe gwe gukola bulungi era asobola kumanya biki byakola n'ebivaamu ng'akoze byakola. Era bagamba nti ab'oludda lw'omuwaabirwa be baleeta ekikugamba nti omutwe gwe tegukola bulungi, n'olwekyo be balina okuleeta obujulizi okukakasa nti omutwe gwe tegukola bulungi.
My Lord, on page 10 of our submission, we highlight the fact that the defense has failed to prove the accused's claim of insanity for 2 reasons. First, my Lord, the defense laid no evidence to show that on the 2nd of April this year, when these crimes were committed, that the accused was suffering from a disease of mind which deprived him of understanding the nature and consequences of his actions. In fact, my Lord, in his defense, the accused did not say that he did not know his actions. His evidence was that he only believes that his actions on the fateful day could have been influenced by the distress that he claimed to have had between January and March. He does not say that on April 2nd, when he killed the infants, he had any distress of whatever nature. My Lord, the accused did not say so. Besides, my Lord, even his probable effect, even the probable effect, was simply his belief and not evidence of fact. My Lord, the presumption of sanity is a very strong presumption, and to rebut it, the defense must do more than merely speculating on the possibility of a likely mental disorder. My Lord, the defense bears the burden to satisfy court on the balance of probabilities, of course, the existence of legal insanity at the precise moment of the crime. My Lord, as opposed to what the defense submitted, where there is any doubt, the law favors criminal culpability. And not the other way around. My Lord, we have cited for you the case of Jumba Joshua versus Uganda on page 10 of our submissions. That, among others, sets the material considerations that must be proved for the defense of insanity to succeed. We only want to emphasize the first consideration, my Lord, is that the mental condition or state of the accused's mind is assessed as at the time of the offense. My Lord, not yesterday, but today. So it is not sufficient, my Lord, for an accused person to say that I have ever suffered from a disease of mind. That doesn't discharge the burden. My Lord, we want to interest you in a very persuasive authority that we got from the Philippines. My Lord, on page 11, the authority of the people of the Philippines versus Lito, Pama, Why inandari? Where it was held, while quoting, my Lord, the guidelines of their earlier case of People versus Formigonis, that that there is a three-way test, my Lord, for the defense of insanity. It's a three-way, my Lord, in a sense that first, insanity must be present at the time of commission of the crime. Second, insanity must be established to have been the primary cause of the criminal act. Must be medically proven. And three, must be proved, my Lord, that the effect of the insanity is the inability to appreciate the nature and quality or wrongfulness of the act. Inability to appreciate the nature and the quality or wrongfulness of the act. My Lord, that standard has been applied in the Ugandan case of Uganda versus Mweswa Ivan, which we also quote on page 11. But the sum total of these three-way test, my Lord, is that mere verbal assertions of previous history of mental illness is insufficient. The requirement is to prove insanity at the time of the offense to the required standard. My Lord, we still...
Let's have...
Okay.
Baro yaba mwami Okello walemereddwa okuleeta ebiraga nti Mr. Okello yali mu bitongole tukukola bulungi olw'ensonga tewaleeta bujulizi obulaga nti nga bbiri abaana bano bafiira nti yali alina obulwadde bw'omutwe oba yali tategeera biki bye yali akola. Era mu difensi ye nga yeewozaako teyagamba nti bye yali akola yali tabimanyi, wabula bye yakola akkiriza nti byali bituufu, ate agamba biyinza okuba nga byaliwo olw'ensonga nti yali mwenyamuvu wakati wa January n'ogwokusatu nti teyagamba nti ennaku bbiri z'ogwokuna 2026 nti yali akyali mwenyamivu nti ate nti ekyokugamba nti omuntu omutwe gwe tegukola bulungi balina okuleeta obujulizi wabula si kugamba bugambi nti yayinza okuba nga omutwe gwe gwali tegukola bulungi nti oludda olw'omuwaabirwa be balina okuleeta obujulizi okukakasa kooti nti akaseera ako ke yakolerako ebintu ebyo nti omutwe gwe gwali tegukola bulungi nti ate waliwo omusango gwe wadde owekitiibwa gwa Jumba Joshua nti kugamba nti omuntu omutwe gwali tegukola bulungi balina okugendera ku bintu bisatu. Ekisooka okulaba nti omuntu omutwe gwe gwali tegukola bulungi ekiseera kye yakolerako omusango ogwo. Ekyokubiri balina okulaba nti okubeera nti omutwe gwali tegukola bulungi kyekyamuviirako okukola kye yakola. Era ekyokusatu balina okulaga nti akaseera ako yali tasobola kutegeera nti ekintu kye yali akola kyali si kirungi.
Again, my Lord, this particular defense was established in the case of R versus Magnaton, which we provide on page 12. And in summary, my Lord, the principles set out in the Magnaton case just to re-echo the three-way test, my Lord, that I have already highlighted in the Philippines case. Now, our submission, my Lord, is that the defense has failed in proving any of the laid down principles in the Magnaton rule. And we just want, my Lord, to highlight the first of their failure is their lack of evidence to prove existence of a disease of mind. My Lord, what amounts to a disease of mind? Was defined in the case of R versus Sullivan, whose citation we provide on page 12. And my Lord, on page 13, we draw your attention to the second holding. My Lord, the first holding is equally important, but I just want to highlight the second holding, where the court held that when a man is guilty of a great offense, it must be very plain and clear. Before a man is allowed an exemption, my Lord, on the exemption on the basis of insanity. The court emphasized that that it is not every kind of frantic humor or something unacceptable in a man's actions, or that points him out to be such a madman as to be exempted from punishment. It must be a man that is totally deprived of his understanding and memory. A man, my Lord, that does not know what he is doing, no more than an infant. My Lord, by our nature as humans, nobody has a perfect mind. But for one to claim imperfection of mind as a defense, you must establish that your imperfection is such that you were incapable of appreciating anything, just like you see a baby. My Lord, in our case, the allegations of insanity are simply vague oral references to an alleged distress between January and March, the supposed effect likely to have been caused by the sickle cell disease, and my Lord, the allegations made in this court are the same blanket allegations that were made to PW11. On the police form 24. And my Lord, PW11 was clear that he could not confirm those allegations for want of the medical history of the accused. But in his examination, my Lord, 7 days after the offense,
5 days?
5 days, my Lord, 5 days after the offense, where the accused was, in a nutshell, a person of proper mental understanding. My Lord, we invite you to consider the evidence of this particular witness in as far as his professional findings were concerned, as opposed to the notes of allegations by the accused, whose proof he did not produce. My Lord, besides PW1's evidence, we also have evidence of PW12, rather PW11's evidence. We have evidence of PW12. That had previously examined the accused on private basis, my Lord. Just 3 months, my Lord, before the offense. he still found him to be clear-minded. But also, my Lord, court should consider the evidence from PW 15. PW 15. Especially to the effect that the accused knew that he had killed 4 children. He knew he had killed human beings. My Lord, the defense contends that this particular section, this particular fact was not included in the statement of PW 15. But my Lord, it is trite that not everything that police does or sees can practically be deduced in detail in a statement. The position of the law in Uganda versus Augustine Musana and 2 others. My Lord, this case is reported in 1985 HCB. It's not in the bundle, my Lord. Yes, my Lord, we could. I just came up with